Hey everybody, today I'm going to talk about the importance of the Companies Act. Today we are going to discuss about the historic development of the Companies Act, and let's start with the history. So the history of the Companies Act begins from the Joint Stock Companies Act 1850. It was the first amendment, and it is based on the English Companies Act. And then we have Companies Act 1857, where the limited liability concept was introduced. Then we had the Companies Act 1866, where incorporation, winding up, all those aspects of the company has been introduced. Then we had another Indian Companies Act in 1913 and 1956, which is based on the Baba Committee. Moving on, the Companies Act that we have today, that's Companies Act 2013, is based on the J.G. Irani Committee, and some of the key points or key important provisions of this 2013 Act includes women director appointment, CSR, corporate social responsibility, companies law tribunal and appellate tribunal, and the introduction of one-person company. We all know the one-person company is a company where only one person can start a company, and then the concept of independent director, rotation of auditor, and financial year starting from 31st of March. So these are the key aspects of 2013 Act. So the section 220 of the Companies Act defines the company. So if you want to know some key sections, you can always know that section 220 is one such thing. And then the characteristics of a company based on legislations, based on judicial decisions. The company is considered an artificial legal personality. It's a separate legal entity from its members. It has a perpetual existence. So the company, once incorporated, continues through. And then there is a common seal. There is a limited liability, transferability of shares. The company has a capacity to sue and be sued, and of course, company is not a citizen. So all these factors are based on judicial decisions. So these are the characteristics of the company. And let's go to one section called section 464, and this is in the Companies Act. And why I'm talking about section 464 464 here is because to point out that according to the section, no association of more than 50 people is allowed for business. So if you have something else, if you want to start a business, if you want to make a profit, you must always make sure, if it is of more than 50%, you always make sure that you have to incorporate it as a company. Of course, this does not apply to Hindu undivided family, association governed by special acts, charitable associations, foreign companies, chit funds, stock exchanges, and investment in certain securities. So just note that if you want to make a business, or if you want to make profit out of it, and if it is more than 50%, it should be some sort of a company as per the Companies Act 2013. So the requirement of members, if it's a private company, the minimum requirement is 2 and the maximum is 200. That's the limit of private company. And if it's a public company, you have a minimum of 7 members and it's unlimited. And the other important thing is there is restriction on transferability of shares, while there is no restrictions here in the public committee. So company can become a partner because, as I told you, company is an artificial legal entity. It has a separate entity, and it's kind of a natural person, artificial person. It can become a partner. So what's the difference between a company and a partnership? Now it has to be incorporated. The company has to be incorporated. It cannot come into existence without registration, while in partnership registration is optional. It has a separate legal existence, but there is no independent existence. There is limited liability in terms of company, while in partnership there is unlimited liability. And the members, as I told you, for private it's about a minimum of 2 members and a maximum of 200, and for public it can go up to unlimited and a minimum of 7 members. The company has purposeful succession, but there is no purposeful succession. Partnership can be of maximum 50. Free transfer of shares, no free transfer of shares here. Shareholders are not agent of a company, while partners are considered agent of a company. And shareholders are not involved in the day-to-day management of the company, while partners are involved in the day-to-day business. The key features of 2017, as I told you, maximum members for private company are around 200, maximum directors 15 by passing special resolution, and section 53 prohibits shares at discount, that is split equity shares. Forms of business ownership, there are sole proprietorship, partnership, corporation, Hindu undivided family. The forms of business ownership, you want to know this before learning Companies Act. If it is a sole proprietorship, it's unlimited liability, and there is only one person, and there is no separate law governing sole proprietorship. The limited liability is unlimited, and the ability to procure funds for your company is also very limited in this. Now there is another thing called partnership and limited liability partnership. This is similar to a company in the form of partnership. As I told you, partnership has no separate form from its owners, but if you form a limited liability partnership, it has a legal entity separate from its members. Its motive is to earn profit, and in limited liability partnership, it takes into the best aspects of company as well as a partnership. This is the kind of company that we will be looking in more into Companies Act. This is corporations that have owner and shareholders liabilities are limited and can raise funds through stocks, and this we will see detail in the Companies Act. And there is another thing, Hindu undivided family. It's managed by Hindu law, and there are two kinds of system, and there's one is Diabhaga system and Metaraksha system. In Diabhaga system, both male and female members are involved, while in Metaraksha system, only male members are involved. Of course, these are not a company, but these are a kind of business associations which is recognized in Indian laws. Key points to note, key differences between company and sole proprietorship and partnership. It is regulated under Companies Act. There is no specific statute, and partnership is regulated under Partnership Act. And corporations must, incorporation is voluntary here incorporation is not even required. This is key members. Private has minimum 2 members and maximum of 200, but public minimum 7, maximum unlimited. Liability is limited. Here unlimited, join on 7. So this is a conversion. If the company has 2 crores for a consecutive 3 years or 50 lakhs of share capital, then that must be converted into a public company. Key cases that you have to see are Salomon and Salomon Co-Limited. It says that in this case it said that the company is a separate legal entity, and Lee versus Lee forming a company where an airline pilot was killed. Also considered that the company is a separate legal entity because although the pilot had huge share in the company, he was considered a separate person, and he has to be compensated for his acts. So these are the key cases. So that's it with the Companies Act 2013 basics. I'll go in detail into Companies Act in future videos. Do subscribe to my channel and share this video to anyone for whom this video might be helpful, and thank you.